myself. I'm Craig Cowing. I'm a retired ordained United Church of Christ pastor, and I really don't play keyboard all that well. I play the cello a lot better than I do keyboard. So I'm here rather as not so much as a musician, but as a mechanic. I restored reed organs professionally during the 90s and did about 150 or so instruments during that time, and had some that were pretty frustrating. And to that end, I found that generally the Esteys, I did probably about 25 Esteys, they were generally the easiest instruments to work on. They were most logically built. They didn't have extra parts that you didn't need, like Mason and Hamlin or some other makers, and they were good. So we're looking at patents, and patents you may think might be kind of a thing of the past, but there are still lots of patent fights. My older brother, who used to do pharmaceutical company websites for a living, told me once that there was a patent suit not that long ago between two pharmaceutical companies, and what they were suing over was the design and the location of the line that goes down in the pill. You know, like if you have a pill that you break in half. Yeah. And there was a lawsuit over something like that. I don't know what the companies were, it doesn't matter. So it may seem that when we look back at the Estey lawsuit, or the Estey Burdett lawsuit, that it's trivial, but it really isn't. Especially when you consider what was at stake. The settlement from the district court, the first phase of this very extended lawsuit, the settlement was $161,000 in favor of Burdett. If you put that in today's money, that's $4.5 million. So this was not just pocket change. When the Esteys were facing this lawsuit, they were fighting for the existence of their company, the survival of their company. So it's a pretty serious thing. Burdett is one of the personalities. They're kind of a contrast to Burdett and Estey. Burdett changed the spelling of his name a couple of times. I think it was originally B-U-R-D-I-T-T, and then it became B-U-R-D-E-T-T, and I think for a while it was T-T-E. I don't know. But to give you kind of an idea of personalities, I have here a baffle board from early 1860s Estey and Green melodeon. And Burdett worked for Estey, and especially for Estey and Green, he was the head of the tuning department. So he was a master tuner, he was very good at it. And on the back of each melodeon that he tuned, he wrote in huge letters, Burdett Tuner. So he didn't do anything small, everything was kind of big. And then by contrast, we have Jacob Estey, who was apparently, from what I've seen and from his testimony, even when he was under fire by the opposition's lawyer, was cool, calm, and collected. And it's kind of an interesting contrast. So this whole case is just vintage 19th century language. And there is a cast of characters. I can't go through all the testimony because there simply isn't enough time. But some of the earlier reed organ manufacturers were all called in to give depositions. It's really kind of an interesting thing. And then we find towards the end that they get to Arvid Dayton, who's a rather obscure melodeon and cabinet organ maker in Wolcottville and later Torrington, Connecticut. And when they focus right on Arvid Dayton, that is when the nonsense starts. And it's great. So just to start off, as you said, you should have in front of you, and I think there are more copies of the patent available, but there should be at least a couple on the table. And if you look at the patent, the description actually for a patent is pretty terse. They're generally sometimes a little more flowery. So Burdett applied 3 times for for this patent for the Celeste stop. And the term Celeste does not appear to have been used. I think at that time this may have been more of a European term. I'm not sure about that, but that's my guess. And in particular, I want to call your attention in the drawings on the front of the patent and look at its vertical, the way it's put on the plate. But you will see the arrangement of reeds that caused all this trouble. And there is if you tip it, this is figure 3, if you tip it on its side to the left, reed letter C is going to be the base rank. And letter B would be the, it would be the 8-foot rank. And then above it, letter A is the hot spot, and that is where the Celeste stop was. And this is what Burdett patented. Now, he had 4 claims in his patent, and only the first 2 really become an issue. And the first claim was that there was the opening, if you look at the opening beneath the oblique cell, you'll see that the opening going down into the valve opening is shorter. The term that they often use in the testimony is contracted. And that is one of the things that he claimed to have invented. It was found later that he didn't. The other thing was that you had the tuning. And the way that they created the Celeste tuning, and those who know more about tuning could tell me this, was that they tuned the second set a little flat, not by much. And it was discovered that it would cause the wavering tone. So that's really the basics of what this whole fight was about. And Burdett eventually, in 1867, Estey opened a major branch in a factory in Chicago. And Burdett was sent out to run that factory. At some point, I'm not sure when, Estey sold that factory to Burdett. That became the nucleus of Burdett's own company. They had a fire, I believe it was in the Chicago fire, in 1870, 71? 71, okay. That factory was destroyed, and then he went down to Erie, Pennsylvania, and so forth. So those events all led to the starting of Burdett's own company. So what I want to do is just run through the testimony and highlight the major issues, and they will all focus around those 2 claims. The one claim that the contracted opening, the shorter opening for the center reed, the one that's in an angle, was original to Burdett, and also the tuning, the flat tuning to create the Celeste effect. So what Burdett did in his testimony was he claimed that he was the first person to do this. Just claimed it. And he explained the difference between a tri-reed board and the board with a contracted opening. And the tri-reed board would be if you think of your valve opening, you had all the valve openings, or the openings into the valve opening, in a size commensurate with the length of the reed. As you know, when you look at the underside of a reed board with the pallets off, that the holes for the reeds will taper. Sometimes the pallet valve holes will often not, probably the same length. And his contention was that if you had 3 reeds in a row, in other words, if you had, say, 2 in the front and then 1 in the back, that your pallet valves would be too big, they'd be too long, and they would not work well. Now, some makers did come up with solutions for that problem later on, but at this time, there was no solution for the problem. So that was his claim, that the contracted opening in the middle would make a pallet valve more reasonably sized and easier to work with. And if you've worked on organs, you know how sometimes difficult pallet valves can be, and sometimes they can even work and can do all kinds of wacky stuff that you really don't want. So Burdett's claim was that by having the oblique reed and having it go down into that space, he was using space that was basically wasted in the cell block. And it was. If you just have a 2-rank organ, you know that there's going to be a solid section in between, especially when you get up to the treble where the reeds and the reed cells are shorter. The reason that the patent applications, the first 2 were rejected, and there is testimony about this in one of the depositions, was that the patent office felt it was not original enough to offer a patent. And for reasons that I really still don't quite understand, the patent office did grant the patent on the 3rd try, just when he changed a few words in it. Why they did that, I don't know. Why do people do the things that they do? So Burdett's concern again was that not only was a tri-reed board too big for a pallet, it's also that when you got down to the base, that it would just be too big. You couldn't make a pallet valve that long. So that is in Burdett's testimony, and he felt that it was original enough, and he felt that Estey's continued use of what they called the vox jubilante. They didn't use the Celeste stop. That was their own proprietary name for it, the vox jubilante. And that became a standard stop on Estey organs, I think, for quite a while. What Burdett felt was important was with the Celeste stop was to have it only go down about 3 octaves at best. And the reason was, again, because if you got down to the bass end, you just had too much to work with. So tenor F would be the cutoff point. He did feel that having a half set of reeds was just mechanical. In other words, anybody who knew anything about these instruments could figure that out quickly. And I thought that was kind of interesting. And he also noted, which is interesting because, of course, he claims in his patent that he originated the oblique reeds, was that if you had the reeds obliquely mounted into the reed board at that angle, that in itself did not affect the tuning. Well, it's obvious. If you have the reeds tuned the same, it's not going to make any difference in the sound. So the real hard center of this was the Celeste tuning. And there's a corollary, the oblique positioning of the reeds for a matter of effect. So here's Burdett's own words in a deposition. He's describing the Celeste effect. He says, in Exhibit B, there's one 8-foot full tone set, one full 4-tone set, a full set, and one 8-foot tone partial set. The 2 8-foot set tones are adapted for the purpose of tuning them, one a trifle above or below the other, in order to produce effect which I can denominate Celeste. Okay, he's actually using that term. As no other size reeds can be made to produce this effect so well, while those tones being tuned a little out or a little apart, the individuality of the tone is not lost, and therefore the power of the 2 tones is retained. So Burdett claims that he never knew of, before his invention, of a reed board with 2 8-foot ranks and 1 4-foot. And he also said he didn't know of anybody else who did the Celeste tuning. Now, in what I used as the basis for my research was the defendant's collection of documents and testimony. This is what the Estey's lawyers put together, and it's pretty complete. The only thing it really lacks is most of the depositions from the Burdett side. But the salient points in that are brought up by the plaintiff's lawyers. So we find the best parts of that are in this testimony. And I split up my copy after original copy, and this paper is that later 19th century stuff that it falls apart if you breathe on it. So I have it divided into 4 volumes. And it is 690 pages. So, yeah, so I swam through this, and there's several things, before we get into more of the specifics of the testimony, that I discovered. In historical research, which is really my thing, I'm 67, I've been doing historical research longer than I can possibly remember. It was a thing in my family. And one of the interesting things is that sometimes information that is preserved in documents or possibly in physical objects that is quite valuable was not intentionally saved as a historical document. And so these documents were simply preserved as a record of what was happening with the suit. And I would imagine that this document was one of the things that was submitted to the US Supreme Court. We'll get to that later. But what is also preserved in here is a couple of different things. One is there's social history. And there is testimony from several factory workers at Estey. And these are just people that would have lived in the company housing or wherever in Brattleboro. And these are people that generally history doesn't even know about. They may know they existed, but they know nothing about them. And so we see the words of these average factory workers that really adds color and adds life to this testimony. The other thing is that some of the manufacturers, or several that were started out as melodeon makers quite early. And so we get a glimpse into how a melodeon factory was operated, how many workers there were, what kind of jobs the different workers did. And so we have that as well. And that's really interesting. And then there is just the Victorian stuff. And this is melodrama. The only thing that this case does not have is sex. And as Bob Lindstedt said last night, well, maybe, we don't know that there was, but who knows? But anyway, you've got everything, and we'll get to this, from blindsiding witnesses with accusations of tampering with witnesses, tampering with evidence, and the whole bit. And it's great stuff. It really becomes a circus as we go on. So one of the guys who was called to testify was a man named Moses Nichols, who had worked for several different companies. Nichols had a very high opinion of himself. He claimed that in the 1830s that he invented the reed organ, which he didn't. And he produced as evidence articles from a couple of local newspapers that claimed that, yes, Mr. Nichols invented the reed organ. Well, he didn't. But, you know, he's on a roll, so let him go. And Nichols also was a tuner for a while with Estey. I don't know if he may have been a difficult personality, and one of those guys that goes from one job to the next, and they last maybe 6 months because they tick somebody off and then they go to work for another place and so forth. And you've probably known people like that. I certainly have. So Nichols, early on, and this comes up in one of Burdett's, the complainant's depositions, Nichols basically blackmailed Estey. And he wanted Estey to pay off a debt of $1,000 that he owed on a mortgage. And if Estey wasn't able to pay the mortgage, then what he wanted was to have Estey cancel the debt in favor of favorable testimony to Estey. And if he didn't do that, then he was going to testify for Burdett. Okay, so this is the kind of shenanigans that's going on with this case. It's great stuff. You can't make this up. All right, so Nichols does testify, and he indicates, yeah, he said, I made this kind of a thing, this kind of a reboard with the oblique cells and the tuning and all that. And we find in the testimony that there's several people that claim to have invented the Celeste stop. So it gets to the point where if everybody claims to have invented it, then nobody invented it. It's just happened. Nichols' contention was that a reed board with 2 full sets of reeds and a partial set in the treble for the Celeste on an inclination was not an invention. It's just something that somebody could figure out. And that's the basis, that's the whole basis of Burdett's claim. So we hear from one guy named Josiah Whitney, who was a maker of reed boards. And he claims, or he testifies, that in 1861 he made a board with 2 full ranks and a partial rank in the treble. Also that partial set could be tuned to produce the wavering tone that was so desirable. And probably, for my money, the most important person that testifies on the whole issue of the development of the Celeste stop is Henry Kirk White. And I appreciate in Mark's talk the references to Wilcox and White, which was in my hometown of Meriden, Connecticut. And my great-grandfather, who was a lumber dealer, among other things, may very well have supplied lumber to Wilcox and White. So that's fun. And they did make a good organ. Of course, I'm partial, but Henry Kirk White was the White in Wilcox and White. He originally made melodeons. He made melodeons on his own in London, Connecticut, and I have one of his early melodeons. Then he went up in the 1860s and he worked for Estey for a number of years, and he was a tuner. And like Burdett, he was a master tuner. He was just a master at his craft. And then eventually, when Horace Wilcox in Meriden, Connecticut decided that he wanted to branch out and diversify, he wanted to build reed organs, and they lured Henry Kirk White down to Meriden, Connecticut. And I believe some of his descendants are still down there. And so Wilcox was the money and White was the brains. And they ended up making some really good instruments as they were down there. And went belly up, of course, around the 1890s, like many other companies. So what White testifies is that he first discovered in reeds the Celeste effect by tuning them slightly out of tune. In September of 1865, he was working for Estey. He told R.W. Carpenter, I think it's Robert, is it Robert Carpenter, who also worked at Estey, about the Celeste effect. And then he told Jacob Estey and Levi Fuller. And you probably know by this point that Levi Fuller was the son-in-law of Jacob Estey, and he was also more or less the general manager of the factory. White was asked if he ever told Burdett about the Celeste effect. He says, yes, he did, late November or December of 1865. And so White goes on in extensive detail. He said that the first organ sold by Estey with the 2 full ranks of reeds and the 1 partial rank tuned slightly out of tune was sold in February of 1867. And White repeated in another deposition, and he was called 3 times to do depositions, so his testimony was seen as quite important. And again, he emphasizes that he told Estey, Jacob Estey, about the Celeste effect at the end of 1865 and again in early 1866. And Jacob Estey was quite interested in this because they were hoping to purchase Carpenter's patent for a fan tremolo, which we know, of course, now became universal, basically, in American reed organs. And Carpenter was working on that, and their plan was to purchase that patent when it was finished. But what White offered instead was an opportunity to create a Celeste effect without having to go to the trouble of purchasing Carpenter's patent and then implementing that. And the interesting thing in White's testimony is that, or actually Jacob Estey's testimony, I'm sorry, Estey was deposed about 3 times, I think, and he confirms what White said about the timing of his being told about the Celeste, and mentions again that they were thinking about buying Carpenter's patent. Estey then said that he talked with Burdett about the Celeste and said that, if we can make this work, we won't have to buy Carpenter's patent. And interestingly, Burdett said that White had told him about it, and Burdett told Estey, I don't think it'll work. Now, why he said that, I have no clue. But I think that's kind of funny. Then we come to the beginning of the, in the main tent, okay? Arvid Dayton. Arvid Dayton was a small-scale melodeon maker. I have one of his melodeons at home. Unfortunately, it doesn't have any of the goodies that later became such a bone of contention. His father was a pipe organ builder in early 19th century Connecticut. His brothers also worked on reed organs, and they were deposed in this case for the Esteys. And later on went to make cabinet organs, including organs that became really the heart of the case, that had both the oblique positioning of the reed and the flat tuned set that created the Celeste effect. He says that he made an organ in 1860 that had that, they had both of those features. And this really interested me. He said that he was asked when he learned about the Celeste effect in general, not specifically reeds, but just in general. And he said that when he was at the World's Fair in New York City in 1853, there was a German pipe organ maker, he didn't mention the name, who had one rank in the organ that he had on display, tuned flat. And White said that he had created a Celeste effect. And so, and he said he had also seen a Celeste in Alexander harmoniums, which I don't know if anybody who's anybody an expert on Alexander harmoniums. Did they were they using a Celeste pretty early?
1853 for Musette.
Okay, so early 1860s?
50s.
50s, okay, so there you go. So it's around the same time as this pipe organ maker. Dayton actually had the same reason for putting this reeds, the second set of reeds, on an incline as Burdett did, which was that it would save space. The whole collection of openings into the valve opening would be contracted, and it'd be easier to make a pallet valve that would work rather than having one that would not, that would be too long and might sag in the center. So I want to read you a little bit of a testimony from Arvid Dayton. So the lawyer, so cross-questioning. This one I think was done in live court, or it's a little hard to tell because many of these things are depositions. They would either pay for the person to travel to court, or they would have a lawyer go down to wherever the person lived and do a deposition there. So, question 47, look at defendant's exhibit number 18 and state if you know by whom and when the words principal diapason 15 or 2 octaves above diapason 1859 A. Dayton were written thereon. And this is one of the things that became the absolute heart of this case. The strong implication, not an accusation, but a strong implication that Jacob Estey, none other than Father Jacob, altered one of the Dayton boards that had been entered as testimony, or that possibly Levi Fuller did it, by erasing the pencil markings and then staining the action so that it would obscure it. All right, this is where it gets really tasty. This is great stuff. Okay, so Dayton says, I cannot tell the day that I know of. It looks so much like my writing, I really can't say whether I wrote them myself or not. I wrote some of them on some of them. I can't say whether I wrote them or not. In fact, I wrote the words in this exhibit. Don't you know that these words were written by Mr. Fuller, the defendant, and by yourself, not longer ago than yesterday? Well, I think I wrote some of them, and I wrote some of them, and they might have been written yesterday. I don't know, as they were written before. Question repeated, and the witness requested to make an answer to it. I know some of them were put on yesterday, and some of them were put on before. Read one of those which you know were put on yesterday. Well, I don't know, I can tell. I don't know in what way I can tell. I can't say whether they were put on yesterday or not. It's a common thing to have them put on these boards, in order for a maker to sign his work, which is obvious. So then Mr. Burke, who was the chief lawyer for Estey, states that the witness, at the time he answered question 18, had two boards in his hands, namely Exhibits 16 and 18. And the questioning goes on, and they're really bantering Dayton at this point. And I think the lawyers on Burdett's side, they probably knew about Dayton being called as a witness and being deposed. And what they're working on in the rest of this case, as it's documented in the defendant's collection of briefs and testimony, the brunt of the case is to discredit Dayton and to prove that he didn't make those things when he claimed to make them, and that the Esteys altered the evidence. So Arvid Dayton's brother, Justice Dayton, says that he worked with his brother on and off in the 1850s, and then in 1853, which would actually corroborate with Arvid's claim that he talked to this pipe organ maker and saw a Celeste stop in a pipe organ. Justice says that they worked in 1853 on tuning a set flat, tuning an extra set of 8-foot reeds flat, and creating that. He also says that he saw, I believe, in Arvid Dayton's shop, he saw in 1856 an organ with a slanted partial set. In other words, if you look at that patent, have that picture in front of you, the slanted set that goes down and creates the contracted valve opening. Okay, then we have, this is part 2A, I call this, the Newberry organ. Joseph A. Newberry was a older doctor in Torrington, Connecticut, and in 1866 he bought a cabinet organ for his daughter from Arvid Dayton. And he said he owned it until the previous May, which would have been 1873, when the Esteys, Levi Fuller and Jacob Estey, found out about it, and they went down and they asked Dayton to purchase it back from Dr. Newberry, and then they purchased it from Dayton because they wanted this to be used as evidence. So Newberry is asked, were there any marks on this organ? And Newberry says with a knife, he cut an X and then he wrote his name on it. And he knows that he had this organ before 1867 because his son was married in 1867. So it was last May, and after the organ was reacquired by Dayton, it sat in Dayton's shop for a week. And Jacob Estey saw him mark it with his initials J-A-N, and Newberry was asked about the reeds. And one of the things that was going on at this time, as makers were working to augment their instruments, they would manually add a second rank of reeds on top, instead of making it all at once, the way many later companies did. They would add that on top. So they would have to alter the reed board. They obviously would have to make openings and so forth. So Arvid Dayton was doing some of this. So Newberry was asked if he thought the organ had two and a half set of reeds. He said, I don't know, I'm not musical, it was my daughter's. So, and Dayton was again badgered by the opposition lawyer about whether the organ that he sold to Newberry, which became the real famous Exhibit 21, keep that number in your head because it's going to come up again, if Exhibit 21 was the organ that was sold to Newberry, was it in the original state that as it was sold to Newberry? And then the questioning goes on, was it altered while it was in Dayton's shop during that week that he had possession of it before Jacob and Levi went down to claim it? No. He said, it has not been altered. And then Dayton, this poor guy must have gone out and get a couple shots after he was done, because they really grilled him. Cross-questioning, is Arvid Dayton or any other person, this is what they're asking Dayton. Oh no, they're asking Estey. Is Arvid Dayton or any other person aiding you by contributing any money or in any way in the defense of this suit? Arvid Dayton, this is Father Jacob, Arvid Dayton is not contributing any money or any other person contributing any money to aid in the defense of the suit, nor is this person aiding to defend it in any way or form. So they're really now going after Estey. And they had no sympathy for him. In the testimony, the next person that comes up, and this substantial one, is a guy named Titian Peale. And he must be one of the sons of Charles Wilson Peale, who named all of his sons after famous artists. So that's kind of interesting that he wound up in the patent office. And he dealt with a lot of the cultural things, art and musical instruments and stuff like that. He was one of the commissioners for that. And Peale said that initially, he said, we rejected Burdett's patent because it just wasn't original enough. Burdett submitted it again. Peale and the office felt that it still was not original enough, and so they rejected it. And the third time, maybe they just did it to get rid of him, they approved his submission with a couple, I suspect, suggested changes that they might make in the wording. Not really substantial, but it was enough to make them happy. And so Burdett got his patent in, as he did. Now we go from the sublime to the ridiculous. And there is a lot of testimony about this very important question that I sat up all night thinking about. The question is this: did Arvid Dayton have one of his reed organs on display at the Litchfield, Connecticut County Fair in 1866? Yes. Everybody said yes. And then Dayton was asked, have you altered, is that organ the same one as Exhibit 21? Yes, it was. Is that organ in the same state that it was when it was exhibited at the Litchfield County Fair in the fall of 1866? No, it has not been altered. Then he brings the testimony of people that are opposed. There's several farmers from the Litchfield County area as to whether they heard and saw Arvid Dayton playing this reed organ, and was it the same organ that you saw in Exhibit 21. Okay, don't fall asleep on me yet. All right, so here is the testimony of Herman Cook, who was a farmer in Litchfield, Connecticut. State the day of the month when the fair was held at Litchfield and when it was held at Wolcottville, which is nearby. I could not do it. Would you swear that both fairs were held in the month of October 1866? Yes, sir. You are positive, perfectly positive of that, are you not? I am, sir. How many days were there between the two fairs? I should think probably about 14, the expiration of 2 weeks. Did you see an instrument, exhibit number 21, between the two fairs at Dayton's shop or anywhere? I did not. Did you see that instrument played upon under the tent at the Wolcottville Fair in October 1866? And if so, by whom? I saw it played under there by Mr. Dayton. Where was the tent situated under which you saw it played? It was situated about a half a mile south of Wolcottville in the field of Mr. Seville's. Did Mr. Dayton play it under the same tent at the Litchfield Fair? Yes, sir. And there's page after page of testimony like this.
That must make for good reading at night.
Oh, it was great. In fact, I did some of this late at night. It was fantastic. Now, then Levi Fuller is called to do a deposition, and Fuller is asked about how he learned about the Celeste effect. How are we doing for time? Okay, 11:30, got about 15 minutes, okay. I want to allow a little time for action, so maybe I'll put this on fast forward. So eventually what happens is there are questions. Levi Fuller is indirectly accused of having changed the handwriting on one of the exhibits that would demonstrate that Arvid Dayton made that instrument in 1860 whatever, and that that either Fuller or Jacob Estey had altered it. Presumably it would have been written in pencil, as we know that's usually the way that things are signed, and then that it was stained over in order to obscure what would have been left from the residue from the pencil. So here's a quick exchange that Jacob Estey has with the lawyer who is deposing him. Please state whether or not you ever saw the name of Arvid Dayton written in pencil mark upon the upper surface of the reed board of Exhibit 21. And if so, when did you see the same? State as nearly when you can recollect. I did see the name of Arvid Dayton on the upper surface of the reed board. I think it was about the 15th or 16th of February, and I talked with my counsel, Mr. Burke, about it. Both of us saw it together. I requested him to call the attention of a witness to it by proving the pencil mark or name of Arvid Dayton by one of the witnesses. Question, when did you last see the name on said instrument? I think as late as the 20th or 21st of February, 1874. Whether or not you have ever seen Arvid Dayton write. I have seen him sign his name and have often received letters from him. State if you know in whose handwriting the name of Arvid Dayton which you saw in pencil mark on 1821. It was the handwriting of Arvid Dayton. And then he's asked, was the name of Arvid Dayton still on the organ? No. So, then the questioning, and for this case, this is the Candy Nougat Center, okay? This is the heart of it. They asked Estey when he had when he did his deposition, his previous deposition in February of 1874, did he see the organ alone? Was he alone in the room with the organ at any time? Then the lawyer even asks him for the layout of the room. How many doors were there in the room? Where were they located in the room? And Estey, this guy must have been unflappable. He said, when I got there to wait for the lawyer, I sat down and read a newspaper that I pulled out of my back pocket, and I didn't move until the lawyer called me into his office to do the deposition. So he's saying, no, I didn't alter the evidence. And they tried to make it evidence. So that was really the heart of it. And then there was also the tampering of evidence. It appears that several of the organs, I don't remember if it included number 21, but several of the organs that were offered as evidence were damaged. And they were damaged probably when they were in storage, and the opposition's lawyer had charge of them. So in the middle of all this, Estey and Levi Fuller file a lawsuit against the opposition's lawyer, claiming that they were responsible for the damaging of evidence. Okay? I don't know, I don't remember how that went, but that's just a little sideshow that they had. So Dayton eventually gets off, and then there is even the question about whether Levi Fuller had given gifts to Dayton's children.
Oh dear.
And Fuller says, yes, I gave one of his children had a birthday, and he gave her a child's cup, which at the time was a common gift for children. But he said her birthday was the same day as mine, so that's why I gave her the child's cup. So we've got just about everything. And then Eva Newberry, who was the daughter of Dr. Newberry, is called up to testify, and she describes the organ, number 21, that had been played at the famous Litchfield Fair in 1866. And Dayton is called back up, and then he is asked if in 1873 did he alter any of the organs offered as evidence by the Estes. And he's very emphatic, and he says, no, I did not. One last little thing that they throw in kind of as dessert is Fuller is asked about why they changed their 1867 catalog for the 1868 year by adding pages to it. In other words, they were doing something sneaky. Well, Fuller said, well, we introduced the Vox Jubilante stop in 1867, and in order to cut down on costs, we took the 1867 catalog and added some pages to it, including new models that had the Vox Jubilante stop. So they were just going at this from all sides. Okay, so eventually the case is decided in 1878. The judge sat on it. One of the judges died while this was being considered. I came across an article in a newspaper from, I think it was somewhere in Connecticut, where they basically lampooned the whole thing about how long the Burdett versus Estey case goes. So what happens at the end is that the case is decided in favor of Burdett for those first two claims. The one claim about the reeds at the oblique angle, and the second claim about the Celeste tuning. And eventually a court master is appointed, and it is decided that Estey owed Burdett damages to the tune of $161,000, which would have amounted, as I said earlier, to $4.5 million. So obviously Estey appealed it, and since it was a district court, the next court it would go to would be the United States Supreme Court. So it was in the Supreme Court for several years, and I tried to get a copy because I really wanted to see the arguments, because there's no testimony in Supreme Court cases since they're appealing previously decided cases, not judging new ones. So I tried calling a law library in Connecticut. They couldn't really help me. I tried, eventually got so desperate, I called the front desk at the United States Supreme Court.
Wow.
And talked to somebody and said, we don't have anything that old there. You want the National Archives. So she gave me the number, called the National Archives, and they really couldn't help me. So I was disappointed that I couldn't find it. But someday, it is listed on Amazon in a reprint of landmark U.S. Supreme Court cases, but it's been out of print since I started doing this research. So if you ever get a hold of the Supreme Court transcript of all the arguments and the exhibits and everything, please let me know, and I will drive to where you are and get it, because I can just imagine what it's like. So in 1883, the case was decided by the the October term, 1883. And what they did was that they reversed the decision. Their decision, the circuit court had decided that those two elements, on Exhibit 21 in particular, so that was really the heart of the case, was Exhibit 21, that what was in Exhibit 21 did not contain elements from Burdett's patent. So that could not have been used as evidence that somebody else was coming up with this before Burdett. The U.S. Supreme Court flipped it right around and they said, no, we found that the way that Exhibit 21 is built is the same as Burdett's patent, and it predates Burdett's patent, so they remanded the case, and it was overturned. So this case was during the 19th century, a very famous patent case, and it's considered, apparently from what I can see by legal scholars, one of the nastiest patent lawsuits, patent infringement lawsuits in U.S. history. So if we have a few minutes, I'll take questions if you have any.
The silliest.
Were costs awarded to either side, at both the district and the Supreme Court?
Not that I can tell. I think they just basically threw it out. Yep.
Did they ever play the organs during the trial? One, and number two, does that organ still exist?
No, not that I know. In the depositions, they don't have anybody actually playing. They do have a number of times, especially Dayton or Estey or Fuller is asked about Exhibit 18 and Exhibit 21. 24 was another one that they used a lot. And would you look at this and tell me what you see? But no, as far as I know, there was no music played. At least some of this played out in the form of depositions. I don't know offhand how much of it took place in a live courtroom. Some of it probably would have, but no, there's no, as far as I know. There may have been in courtroom, you know, in a live courtroom where I didn't have documentation for it, but not the depositions. Yeah?
Did Dr. Newberry's daughter ever attest to the 3 reeds and the Celeste tuning of her instrument?
Yeah.
In what? On support of which side?
The Estey side.
Okay.
Yeah, she said, because she was the one that played it.
Right.
So she knew that it had the half set of reeds and it had the Celeste effect. So yeah, she said, yes, it had that. Yep.
Now, was Exhibit 21, was it an Estey or a Burdett organ?
It was a Dayton organ.
Oh, a Dayton?
Yes.
Okay.
Yeah, the whole thing was that they were trying, and they bought 3 or 4 organs from Dayton, was to prove that somebody was doing this, not necessarily Estey, before Burdett got his patent. That was the thing, and Dayton was the one they set it up. But there were other people that did it. So it's
they
clear.
wanted to invalidate the patent.
No, it didn't. The patent stood, as far as I know, and I may be wrong on that. I didn't go look in to see if the patent still stood. I don't know that offhand. Yeah.
Tampering is what I'm most interested in. Who do you think did the tampering? Because it sounds like it was tampering.
I'm sorry?
Tampering, who did it, based on what you studied?
Well, they interviewed in the deposition some of the guys that worked in the shipping department in New York City where the organs were destroyed or damaged. My guess is that some factory worker was paid an extra month's wages and handed a crowbar and a hammer and said, oh, by the way, that back door to the loading dock is open. Why don't you go and see if you can smash up a couple organs? I think that's what happened. And who paid him, I have no idea. But I think that's what happened. I think somebody just paid a guy to do it. Yeah?
Hi, I'm taking apart a Navy case that with my first restoration. I noticed that in 5 or 6 locations there are different names that are stamped in with a hammer, and so I'm wondering if rather than written in pencil, they're embossed. So I wonder if that came after, so that as to not be able to erase it, or.
That's not a result of this. It appears as though foremen and other, maybe not individual workers, the lowest level workers, but foremen at least had their own personal stamps. And you see that going back into the 1850s in some case. So Dayton just may not have done that. But that's, in a lot of cases, you see that. So you see them usually on the reed board.
Just as an aside, do you
Yeah.
know if the workmen had to apprentice before they earned that stamp, or if it was just, if you're hired, you get a stamp,
That's a good question. I think it may have been a matter of position.
or a company?
Yeah, I don't think that the people that would have signed ST organs up until, I don't know the cutoff date, but they were generally signed on the 2nd and 3rd key on the bass end. with the date and with the serial number and the person's name. My guess is that the individual workmen, people who were actually sitting and reaming out the read boards and so forth, did not have their own stamps. I think they would have been foremen. Yeah, over here?
I'm sorry, you said you couldn't find the transcript in the court records, or you said you couldn't find the transcript in the court records, or?
Not so much the live testimony, because what I was not able to determine was how much happened in a live court like we would expect today, and how much of it happened through depositions that were submitted. So I'm not sure about that. I would love to find if there is live testimony and a record of it, but what I don't know is how much was recorded back at that time. Because now you have stenographers, in fact, sometimes it's automatic reading of verbiage, and you can get an exact record. Yeah.
Repeats are been signed on the key or the keyboard, as you said, 2 to 3 up from the base.
Yeah, for Estey's, and other makers did that. Some makers, you will see a signature near the center of the board.
But on the board or the key or?
Well, let's say the keyboard, on the tail of the key.
Tail of the key.
Yes, so Estey will have, they usually didn't do it on the key number 1. It would be the second and the third key. And it'll usually be dated, and then there'll be a signature that presumably is the person that was maybe checking the organ out before it got crated up and sent to wherever it was going to go. Or that it was the statement that this organ is done. Kind of like Burdett signing this baffle. When he was signing it, I was saying he had approved it, yeah, and it was ready to go. But it varied from one company to the next. Some companies you never see signatures.
I may have missed this, but what year did the suit start? And what city?
It started in 1873,
Okay.
and it was filed in the Vermont District Court.
So they had to travel back.
Yes, there's travel involved. They would send, the lawyers would go down to Connecticut, especially with Dayton. I don't think Dayton ever came up to Brattleboro. But I don't remember because I didn't look at that. But he may have come up to Brattleboro. But a lot of these people, they might be deposed. They may not come up to Brattleboro, let's say, but they might go to Hartford or something like that and be deposed in a lawyer's office there. So there was a lot of that because obviously travel wasn't as easy as it was. Okay. Any other questions or comments? Okay, well, I guess we're finished.